Yeah, today we're going to talk about Secure 2.0, and the reality of it is that these changes really do affect our clients. There's some opportunities, there's some planning that needs to be done, and we're just hoping today to give you a little bit of a background on that and alert you to some issues. Of course, Secure 2.0 has passed, but we don't have the regulations for it. So there could be some things that could change or are yet to be determined. So as the slide indicates, I'm Julie Steinbacher, and our firm, for those of you who don't know, we have offices in State College, Williamsport, Wyalusing, and Wysox, and we really focus on estate and elder law issues, anything from Alzheimer's to Medicaid to special needs planning. Also, I am the author of a good many books, and just like at this seminar, my goal is to provide education information to people so that they can make the best decisions and plannings for themselves. So if any of these books are something that you desire or you want for a client of yours, feel free to reach out to Kyle, and he can see that you get some of them. Also, really important to understand that at our firm, we not only focus on elder law and estate planning, we have a deep knowledge in it. So I'm a member of ACTEC, and there's very few, I think like 6 attorneys in all of Pennsylvania that are a member of ACTEC. I do have a specialized degree in elder law and estate planning. So I have an LLM, which is a master's beyond a law degree. And we just try really hard at our firm to do a really good job for our clients.
Yep, and then, so I guess I'll go ahead and introduce myself before we get in. So I saw some familiar names on there, but for those of you who don't already know me, so I'm Landon Hodges. If you're picking up an accent, I'm originally from North Carolina, did all my schooling down there, came up here in January 2017, and been with the firm pretty much my entire career, promoted to partner in 2021. I still manage our wealth protection and complex estate planning stuff in Williamsport, or sometimes known as I'll handle the weird stuff too if we need to, but then I also man our Wyalusing and Wysox offices, and we got a good team and a good system up there, but from all aspects of what we do, so from estate planning, long-term care planning, wealth protection planning, special needs planning, I can be involved in all of it. So not quite super lawyers yet, but I have been recognized as a rising star from 2020 on. I'm also a member of the board of directors for our local Center for Independent Living here in Williamsport, and I am on the board of directors of the North Central Pennsylvania State Planners Council. So you'll see me more and more out there as we go, but kind of not doing as much right now because I did become a father on March 10th. So I'm still awake and alert, and I'm here to still serve our clients. And as time goes on, I might get a little bit more tired, but hey, we're still standing. So next slide here, I got to have it in here because so Mount Airy, North Carolina, those of you that don't know, is also known as Mayberry from the Andy Griffith Show. So it's where Andy Griffith was born and raised. And I had Kyle made this slide a long time ago. Honestly, I just think it's great. So I use that one as much as I can, but that's enough about me for now. So I'll start us off by, so what we're talking about today is Secure Act 2.0. So let's kind of recap with Secure Act 1.0 because it's not really that old. So Secure Act came about, it was effective in January 2020. And one of the big changes that it made was a 10-year payout on inherited IRAs. So it used to be, to go recap even further back, before Secure Act, if you died with an IRA in your name, your children could inherit that IRA, and their required minimum distributions would be calculated based on that beneficiary's expected lifespan. Now, because of course the IRS has a chart for everything, and apparently they have a chart that can say when you're going to die. They can try to beat them, but now they changed it to say, well, people are dying with really large IRAs, so how do we get a piece of that? So now they've changed it to say that the default rule is if somebody inherits an IRA, that IRA must be paid to the beneficiary in 10 years. unless that beneficiary meets some specific exceptions. So for example, a spouse, if you die and leave your IRA to your spouse, he or she still gets the lifetime stretch. Likewise, your children that are minors, so not just minor people, but if you have children that are under age 21, then they can stretch to 21, then start at 10 years from there. Any beneficiary that has special needs or is chronically ill, I'm going to talk about those definitions here in a little bit because that's one of the things that's changing, or a beneficiary that's less than 10 years younger than the person who died. So pretty much though, unless a beneficiary does not fit in one of these narrow exceptions, we're talking 10 years. Another big change was RMDs, which, sorry about the typo there. I just noticed that we'll fix that one in going forward. But required minimum distributions, or RMDs, used to be for anybody over 70 and a half years old. That went up to 72 under the Secure Act. So what's changed? Let's going to give an overview of Secure Act 2.0. So as Julie said, it's passed, but we don't have the specific regulations. So what you're going to see today is kind of general, but it was included at the large spending bill at the end of last year, signed into law right at the end of 2022. So we're still learning a lot about it, but there will be some changes that we're going to kind of go over. We're going to go over what we know, with the caveat that as regulations come out, things will kind of move from there, but we've at least got a framework. So, why would they do this, or what's the tax strategy here? Well, as we know, baby boomers are aging, and over the next few decades, as baby boomers pass away, we're going to see one of the largest wealth transfers in our history. And of course, the IRS and Congress is sitting there looking at how can they get a piece of that, really. And honestly, this is a way of, to put it bluntly, increasing taxes in a politically palatable way. So they can't just say we're going to increase the taxes on your income, because then no one that's in Congress now would ever be working again. So they'll say, oh, we're going to make these really complicated laws regarding your IRAs and tax you that way. So that's kind of the overview. That might be the Landon opinion part of it, but I always like to figure out the why of it. But so I mentioned with required minimum distributions that Secure Act 1.0 went from 70 and a half to 72. So once you reach that age, then the IRS will make you start taking parts of your retirement account so that they can tax them. That's going up to 73 this year. So if you're not 73 yet, then you can hold off till 73. And then that's going to schedule to go up to 75 in the year 2033. And then they are going to reduce the penalty for failing to take your required minimum distributions to 25% for most folks, 10 in some other cases, which is up from the 50% penalty now. But at the end of the day, it's still not advisable to miss your RMDs. So be aware of these ages. If you've already started RMDs, my understanding is that you will just continue. But for those of you who have yet to turn 73, that is going to kick in this year. I'll turn it over to Julie to talk about changes on 401ks.
Great. And before I jump into that, I did, as Landon talked about, it's sometimes good to look at what do these changes mean. And I just did some calculations. So increasing the RMD age. Now, understand, everybody can take out money out of their IRAs, 401ks prior to the RMD age, but that's really when you're saying you're required to make a minimum distribution. But if we increase it from 72 to 75, and then know that because of COVID, the life expectancy tables change. So for the first time in a very long time, the life expectancy has reduced. So if I look on that chart, like Landon was talking about, where the IRS predicts when I'm, should pass away, for the first time, I'm going to see a smaller number. So I used to, maybe it was 27.5 years, and now it's 26.5, for instance. And so when we take those two things together, if we just had an IRA of, let's just say, $1 million, just because it's easy math. Before, what if we took that out at 72, we would divide that by 27.4 years. That would be your life expectancy at that point in time. And if we did that, we'd come out with $36,500, and that would be your RMD. If we wait till 75 before taking out our RMDs and add the fact that the life expectancy tables have changed, we would have to take out $42,750 a year. So it's interesting, not a huge bump, but it does affect it. So, that's about a quarter more that the person's ending up taking out. And so I think that's important. The other thing I want to make sure is everybody understands, this was put onto a spending bill, but part of any spending bill is trying to figure out how do we pay for it. And so part of how they're trying to pay for it is in Secure. Again, let's say I had that $1 million IRA. Prior to Secure at all, I would have been able to give that to my kids and they would take it out of their life expectancy. So take out, $30,000 a year, $20,000, depending on their age. And now under Secure, they're going to have to take out all of it within 10 years. And so if I did it just evenly, which I don't have to, but if I did, it would be $100,000 a year. The government gets more money because I have to take it out faster, but also I have to take it out at higher amounts, which puts me into higher tax brackets. And so just so everybody kind of understands how that works. But there's some, with all laws, there's, I think, good and bad. There's a mixed bag. And some of the changes they've made for the RMDs for Roths are actually pretty good. So currently some Roth IRAs have no RMDs during the original account owner's life, but that's not the case for Roth 401ks. However, under Secure 2.0, starting in 2024, the pre-death distribution requirement would be eliminated. And so I don't have to do RMDs for Roth 401ks. There's also, for business owners on here, there's also an automatic enrollment. And so what used to happen is somebody would have to want to enroll. Now it's going to be an automatic enrollment. And if they don't want to, they're going to have to opt out. And that's important because, the reason the government's trying to do that is to get more people to save for their retirement. But also in that, there's going to be more people who are accounted towards that, because there's going to be more people who part-time workers that would end up being eligible. So starting in 2025, employers that provide newly created 401k or 403b plans have to automatically enroll their workers into it with an initial contribution between 3 and 10%. Now, businesses with 10 or fewer employees are going to be excluded, and that are in business for less than 3 years are excluded. So they give some people some time. There's also bigger catch-up contributions for older retirement savers. So currently, you can put an extra $6,500 annually in your 401k once you reach age 50. But this would increase that to $10,000 starting in 2025. But interestingly, for savers between 60 and 63, so you have just a small time period that you can do those additional contributions. Any catch-up amounts would be indexed for inflations. And there's a lot going on right now with the tax law that's just automatically indexing things for inflation. That's how in other years we'll get kind of odd numbers. The Insured Retirement Institute estimates this will allow an additional $9 billion in savings for older workers over the next 10 years. So they're really assuming that people are going to make these contributions and catch up so that they have enough money in retirement. All catch-up contributions are going to be subject to Roth treatment, except for workers who earn less than $145,000. There also are broadening the 401k match options. So it's easier for employers to make contributions on behalf of employees making student loans instead of saving for retirement. It's really kind of exciting. So if somebody pays down their student loan, that can count as like a contribution towards an IRA and then, or 401k, I'm sorry. And then the employer can just match it. So let's say that, just for an example, they pay down $500 on their student loan. The employer can match that $500 as a 401k contribution. So it's really trying to help people who are caught between paying down their student loans and saving for retirement.
Yep, and that's a particular issue that's near and dear to my heart, or maybe my creditors' hearts. Somebody cares, but this is also important for employers to note too. So this slide kind of shows the pain of that situation, in that studies show that Student debt really does have a big effect on the overall savings of younger folks. So by age 30, people who with loans only have saved about half as much, which kind of makes sense because, a good portion of their income going towards paying off those debts. So what the Secure Act is going to do is they're going to make it so that payments towards a student loan plan can be treated, just like Julie said, as a contribution to the 401k, so that the employer can make a matching contribution. And this will apply to 401ks, 403bs, simple IRAs, 457b plans. It looks like it's going to be pretty broad once the regulations come out to allow whatever sort of employer-sponsored retirement plan that you've got. Hopefully, they're going to be able to link that to payments to pay off student loans, with the expectation and hope that those people who are paying back student loans don't fall behind, like what they're potentially looking at right now. It's kind of consistent with that. They've broadened use for unused college savings money. So several of you are probably familiar with 529 college savings plans. One of the things we're going to do is allow, and a question I get quite a bit is what happens if somebody doesn't go to college, or they go to a trade school and don't use all the money that's in their 529 plan. Well, one of those options, again, part of the plan that we're trying to do here is we're trying to encourage retirement saving for younger folks. As long as that 529 plan has existed for more than 15 years, then the beneficiary of it might be able to roll over any unused portion of that 529 plan into a Roth IRA within limits. So it's going to be subject to your typical Roth IRA contribution limits. But again, this is a good option for those who have 529 funds left on the table and still want to get some sort of tax beneficial retirement plans. All right, so moving on from the education side of it, so there's also a change to how 401ks are treated with part-time workers. Now, with this slide, it's important to differentiate between part-time and temporary workers. So this would still be I guess a non-temporary worker, but a part-time workers who go between 500 and 999 hours. You got to watch out for that 1,000th hour, but 999 hours for 3 consecutive years would be eligible for their company's 401k. That's under the old plan, the Secure Act 1.0 will say. So Secure 2.0 is going to take that down to 2 years. So again, that differentiation between part-time and temporary, well, if you've been working there for 2 years straight, I don't think we're considering you temporary anymore. So we kind of want to bring you into those benefits and try to expand the pool of benefits available to folks. And then, yeah, so the significance of that 999 versus 1,000 is that if you're working 1,000 hours a year, then companies are already required to grant you these, into their 401k plans. But now, yeah, if you've been doing long stints of part-time work, those people are also going to be included in those plans. All right, and then this slide is we're talking about emergency savings here. So again, I like these longer slides because it's, well, those of you who've seen me explain things, I got to get into the why. What's the background? What's the pain that's being addressed here? And so on this one, it's the fact that a lot of Americans don't have enough money on hand to cover an emergency. And when somebody doesn't have cash on hand, typically where is their next best accessible cash? I mean, they're not going to sell their house to cover a $5,000 emergency. And what we're finding more and more is that is their retirement savings. But if you're under age 59 and a half, you've got a 10% penalty on any distributions out of your retirement plans. So not only are these people getting whacked with income tax, they're getting whacked with a penalty for dipping into that IRA just to cover the emergency. So in order to try to meet that burden there, this will allow for employees to withdraw up to $1,000 from their retirement accounts without having to pay that 10% fee. Essentially, we want to try to reduce the pain of people who don't have cash on hand to cover these emergencies without penalizing them for not having it on hand. Likewise, and this is not really tied to IRAs or penalties like that, but companies can also allow workers to set up emergency savings accounts, which would work kind of like an IRA or a retirement plan contribution. So, up to 3% of their salaries would go into this emergency savings account that would cap out at $2,500. But then once they reach that cap, any additional amount they try to put into that account would roll into their retirement accounts. So this one's less about encouraging long-term savings, but making sure that you've got that short-term net, I guess. I was trying to think of a good term for it, but that short-term safety net. There it is. So to make sure that you can cover any sort of shortfall during an emergency. Well, and then let's see here. All right, so a federal matching contribution. So again, this is kind of consistent with that lower income, people who have lower cash on hand. There are tax credits that could be involved that would allow for government matching to contributions to retirement plans. Back to the theme of trying to encourage long-term savings, which I guess kind of loops back to they're going to tax them eventually, but we want to encourage it in the short term at least.
So one of the things that the Secure also does is really helps create tax credits for small businesses that let military spouses enroll right away in their plan and qualify for immediate vesting, which is really important because a lot of times those spouses move often and don't stay in one place long enough to be eligible for a plan. And so that's I think a really good part of Secure 2.0. We're also in this situation Secure really is replacing that savers credit with a direct government matching contribution to a taxpayer's IRA, matches up to 50% of an IRA retirement contributions. But I mean, this, you have to look at the phase outs. The phase out between $41,000 and $71,000. So, it's really helpful. Again, the idea of really trying to get people to have some sort of retirement savings moving forward, no matter what their income is. So I actually kind of like this. So in every state, there's already unclaimed property. And actually, one of the things that our office does is we're always every client that comes in, we actually look for unclaimed property. And part of that is that when somebody passes away, it's kind of hard to deal with. And when they're alive, it's pretty easy. And in my career, I've actually had one person where we found $80,000 of unclaimed property. Unfortunately, the person was already in a nursing home. But I've also had helped a doctor who found a pension. We found a pension that was worth about $160,000, just things that they hadn't thought about and didn't realize. So there's now a national online searchable lost and found database for Americans' retirement plans at the Department of Labor that will allow retirement savers who might have lost track of this. Can't imagine that, but I've certainly dealt with it. The ability to search the contact information of their plan administrator. I think for me, more often, it's not that people don't know that it exists. It's just that we don't even know who to contact anymore, like who is the plan administrator. And so I think this is actually a helpful thing because sometimes there's benefits. Right now, I'm working with somebody whose husband passed away, and I'm reading the manual, and I think she should be getting some benefits. But because the place is no longer in business, not sure who to contact. And so if this really did have a name of a plan administrator, a contact person, and it was required by everybody to have that, that might really be helpful.
Yep, and consistent with that, I mean, I can't imagine somebody losing track of their own retirement, but at the same time, we deal with a lot of powers of attorney or children that some families just don't talk about this stuff. It always surprises me, but the amount of things that scavenger hunts that we have to do to help find parents' assets. So hopefully that'll be useful. But So I mentioned earlier that there are some changes to the special needs planning side of this. So if you recall, one of the changes in the Secure Act was that 10-year payout across with inherited IRAs. One of the exceptions to that was a beneficiary who has a disability or chronically ill. So that definition has been tough to pin down. Mostly, and the easy rule of thumb to use is if you are disabled as defined by the Social Security Administration. So if you're eligible for Social Security disability, then you are disabled under the way that this law reads too. But one of the things they needed to clarify is that the standard that Social Security uses is really tied to your ability or inability to work. And so since this particular law, we're talking about inheritance now, so this might deal with minors. So if you're dealing with a definition that ties whether or not you're disabled to your ability to work, well, how do we do that with a 7-year-old, for example? So this kind of clarifies that. I know it's kind of a minute situation, but it's one that certainly does come up. So the Social Security definition of disabled still works, but that is tied to ability to engage in substantial gainful activity, which again is tied to the ability to work. So for a minor specifically, we've changed the definition to medically determinable physical or mental impairment that results in marked and severe functional limitations that can be expected to result in death or be of long-term and indefinite duration. So there is your clarification, and hopefully, and I do think that even though it's a little wordy, that's IRS code for you, but I think that that's much more workable and determinable for a medical professional to make for a minor than having to figure out whether or not they can engage in substantially gainful activity when they're a child. And then one other note at the bottom. So that's what we're talking about there, is whether or not a beneficiary is disabled to determine whether or not they can qualify for the lifetime stretch of the required minimum distribution of an inherited retirement plan. Now, but if you've worked with our office, you know that if there's a beneficiary's supplemental needs, we're most likely going to be recommending that there's a trust set up for that person's inheritance. So how does that work? Well, let's kind of do a Secure Act recap here. A trust for the sole benefit of a person with a disability can see through, so I guess that would be considered a see-through trust. So the rules that would apply to the beneficiary of that trust will apply to the trust. So all that being said, what does that mean? It means that if the sole beneficiary of the trust is disabled, then you can get a lifetime stretch. But the question that came up of what happens, do we look at the remainder beneficiaries? So, okay, disabled beneficiary dies. Do we look at, who comes next? And one of the clarifications that's going to be in these proposed regulations would say that the fact there are charitable remainder beneficiaries in this trust does not disqualify the lifetime stretch. So all that being said, you've got this trust set up for a person with a disability. The disabled person is the lifetime beneficiary. Upon their death, trust pays to charity. We don't have to take that second level. We don't have to look at that second level. We would stretch the required minimum distributions for the disabled beneficiary's life. Then at the end of their life, everything pays to charity, who doesn't pay taxes anyway. So at that point, we don't have to keep going down the rabbit hole there. So that's a great clarification, and it makes us be able to set supplemental needs trust as beneficiaries of retirement plans and feel safer doing it. All right.
So, what are some steps to take? One is review your retirement assets and really, take a look at, if you were to pass away tomorrow, what does that really mean to your beneficiaries? And for many of you, it means that they're going to have to take it out over 10 years. Now, obviously, Landon talked a lot about the exception for children who have special needs or minor children. There are some exceptions, but for many people, what's going to happen is that the children's going to have to take it out over 10 years. And we want then to say, well, is that okay? Based on the amount of assets we have, are we okay with that outcome? Or should we be exploring? And on the slide, it talks about exploring charitable trust, but I also can tell you just even charitable donations. So one of the things that we would look at is if you have a child who has a special needs, maybe they should be receiving more of the retirement assets because they can stretch it, where a child who doesn't have special needs might receive another asset. If I want to give to charity, I need to be doing that, out of this qualified money more now than ever before. And some of that could happen during life. And so again, it could be a named beneficiary, or the reason the charitable trust is up here is that we're seeing a real uptick in that. We're seeing a lot of people who would want to use some sort of a charitable trust. I actually just talked to a client today where when they pass away, there's going to be a life stream for a person that's very important in their life. And then upon their death, and then upon that second person's death, it will end up going to charities and, local charities where they live. So really important. The other thing is that for everybody on here, even if you've come to our office before, even if you're our client, you really do need to make sure your beneficiary designations are up to date. Because if you came to us before Secure 1.0, your beneficiary designations, if you have a revocable living trust, may just be that revocable living trust. And one of the technicalities of Secure is that instead of naming that revocable living trust, we need to name some sub-trusts. So like in my situation, and I'm married to my husband, Donald, and we have 3 kids. And prior to Secure, I would have just said the beneficiary of my IRA is the Donald and Julie Trust. And that would have been fine. And now what we need to do is to say, well, no, on the death of the second of us, it would be Courtney Subtrust, Steffi Subtrust, and DJ. So it has to name down right into that. And so that's just a little technicality. And again, some of that, we've never really gotten the regulations about it, but it's still something that bothers me. So every time I'm meeting with a client, and I see that, I go back. I also, this isn't anything you have to have us do, but always it's something as our clients, if you are our clients, we're always willing to do that. Get on the phone, talk to your advisor. If you are an advisor, I'm happy to spend time, explaining to you why I think the law requires this. I think that's a really important. Then also, if you're a business owner on here, you really do need to review the plans at your office, especially if you have a 401k. And really for 2 things. One, is it in compliance? And like Landon talked about, that temporary worker versus a part-time worker. And everybody used to be like, oh, we don't have to do it because they're just temporary workers. I don't know. 500 hours over a few years, they are going to trip it. See, before, a temporary worker probably never tripped the 1,000 hours, or less likely to, and they had to be there for 3 years. And so a temporary worker by definition wouldn't. But now I'm concerned how that's going. So 1, are you in compliance with what you're doing? And then second, does it work the best? And one of the things that we didn't talk about on here, but actually it's probably one of my more, I think one of the more exciting parts of Secure, and didn't realize it wasn't. I've done a couple of different PowerPoints and didn't realize it wasn't in here. But for those of you who have 401ks, one of the new parts of Secure is that if you make a Roth contribution on a 401k, it can't be as simple, but on a 401k, you can make that Roth contribution. And when the business makes that Roth contribution, that is pre-tax dollars. So really you're getting money in there and it's never taxed. Now, whether that's a loophole in the way the law is written right now, I don't know, but that's really exciting. So I think, again, those 2 things. 1, are you in compliance with all these changes? But then 2, does whatever you're doing work the best it possibly could? And so, I'm even looking at that at our own office of, should we be doing things differently to take advantage of some of these? Because with all these laws, there's give and take. And we have to think about, are we doing it? I also think for any of the other business owners on here, I think some of this, we have an obligation to talk to our staff about. Certainly some of the savers credits, I think they're wanting businesses to mandate that. I don't know how I feel about that. but certainly talking to staff about, would we want to set that up? And all of that for a business, you have to then administer it, which is a cost. But I think there's a lot in here. And I think it's something that people should really pay attention to. I know in the time that Landon and I have, we're just trying to put out some issues. We can't possibly on here teach you the ins and outs and how it all applies to you, but just to give you some issues to be aware of and to issue spot to take further action. So if anybody does want to take further action, you're always welcome to schedule a review appointment with us. So by you being on here, you probably are either an advisor or you are already our client. And so if you go to chatwithsgy.com, and if you click on that, you'll open it up to a calendar that you would be able to schedule a 30-minute appointment. And that's going to be a fact-finding mission, finding out what all you are interested in and want to think about. And then from there would be an appointment scheduled with Landon or I moving forward. So again, you can open up your browser right now, put in chatwithsgy.com, and that'll open you up to a place that you can make an appointment. Of course, you can always call our office, but many times people like to schedule online anymore.